Welcome to You Can Win in Court. Sometimes it's not enough to be innocent. The legal system is complex, and occasionally the innocent are wrongly accused. Here we will discuss in layman's terms the nuances from real court cases to provide insights on how you can best prepare to get a fair chance in court. And now, please welcome your host, Dr. Petra Dieter.
Welcome. And today we are going to be talking about consumer rights against debt collectors. And with us today, we have attorney Mark Tischhauser from Tischhauser Law Group in Tampa, Florida. Hi, Mark. How are you?
How are you doing?
Good. Thank you so much for being here today.
It's my honor. I'm happy to help out.
So I know that you have a lot of experience in this area of the law. Could you please share with us your experience?
Sure. For 30 years of trial practice here in Florida, I've been at the forefront of a lot of litigation, suing debt collectors and holding them responsible for compliance with a lot of laws that exist, like the Federal Fair Debt Collection Practices Act is one. Florida uniquely has its own special component called the Florida Consumer Collection Practices Act. And then you have this myriad of alphabet soup consumer protection statutes under the CFPB, regulated by the FTC, starting with the ABC. So it goes across a whole bunch of different statutes that apply to different circumstances.
Wow, so it's a very complex area of the law.
It can be. It can be. One of the advantage of it is that the legislatures, both federal and state, stepped in some time ago to try and regulate that area of law to protect consumers, and unique to both of those statutes, particularly the federal FDCPA or the Florida FCCPA, we lawyers get to hold the posture of a civil attorney general for individuals. So instead of going to the attorney general for the state of Florida or the federal attorney general, you can hire an attorney who kind of acts as your own private attorney general to enforce that law, not only for the consumer, but for all the consumers of the state or nationally as far as the federal statute.
Oh, so you're talking about class action or?
Well, class actions could be some of that, but here's an example.
Okay.
When you normally file a lawsuit against a debt collector, traditionally, any lawsuit is going to be based upon the rights attendant to an individual. So if your individual rights were violated, when we file a suit, we're trying to get you a remedy for your individual rights. The Florida Collection Practices Act and the Federal Fair Debt Collection Practices Act elevate those cases to a public purpose. And what that basically is that by prosecuting debt collectors that violate those statutes civilly, that not only are we helping our own clients, but we are performing a public duty. We're essentially holding those people responsible that are violating the act financially and punishing them with responsibility that would normally be at the expense of taxpayers. So what we've done, with these two statutes is essentially shift that opportunity to private attorneys to hold those individual companies responsible so that the taxpayers don't have to. That benefits everybody collectively.
Right. So let's talk about how would a case like this typically come up? I assume there's such a broad area, so there could be many situations, but let's just give some specific example of the kind of cases, like how would it come up? Like, let's say somebody go to you and you say, okay, let's file a case. Like what kind of cases are we talking about?
Well, the benefit of that statute, both versions of it, is that it's very, very broad. So there's a laundry list essentially of violations that they're not allowed to do. Because they're construed very broadly, they can apply to a lot of things. And I'll give you a great example. Just moments ago, I was working on a case involving a landlord-tenant case here in Florida that has run across some of the COVID-19 issues with the governor's mandate for preventing evictions here in Florida. So one might look at that and go, well, how do we get from a landlord-tenant case to a debt collection violation case? It'd be a good question. Because the statute's so broad, it allows we lawyers and the courts to find enforcement for some of these things to protect consumers. And in that case, what happened was the governor in Florida issued a mandate barring evictions for non-payment of rent during the COVID-19 pandemic. Now, how that's worked is the governor told the statute that applies to landlord-tenant evictions. Part of that statute, if a landlord is trying to collect rent money when you're behind on your rent, is they serve what's called a 3-day notice that gives the tenant 3 days to pay all the rent or to leave under threat of eviction. Well, landlords that didn't hire lawyers to properly educate them have gone out and put 3-day notices on people's doors demanding that rent. You're not allowed to do that because the governor's order bars it. Because they're doing that trying to collect a consumer debt, which would be rent, they also violate the Florida Consumer Collection Practices Act as debt collectors. So those individuals are now subject to being sued by the tenant for violating their rights by posting these notices and putting them in the position of either paying the rent when they're not supposed to or being forced to leave under threat of eviction, which they can't do. So that's a good example of how broad that could be.
Wow, and I would imagine that that kind of situation is a lot more common now because we're going through this COVID-19 situation.
Yes, absolutely.
So, but what about like in general, I would imagine somebody have a debt, let's say a car loan, or would that apply to mortgage too? Or is that just?
Yes, it can apply to any type of consumer debt. And for both statutes, a consumer debt is a debt that is primarily for personal or household use. So if you look at whatever the debt is, does it fit in that category? So an example.
So including credit card debt too.
I was just going to give you that example. Yes, ma'am. When you have credit card debt as a classic example, which people are running into now because of the COVID-19 debacle, I'll call it, you have people that don't have jobs and haven't worked for 5 or 6 months. Well, they don't have the ability to pay their credit cards, so many of them are in default. So once those accounts are in default, the credit card companies are held responsible for compliance with those Collection Practices Acts. So if they call you 147 times a day, when you say, I don't have any money yesterday, I didn't get a job between yesterday and today, why are you calling me again demanding the money I told you yesterday I don't have? Then they start to get into the harassment or abuse circumstances of those statutes that give rise to those types of lawsuits.
Oh, I understand. Okay, so somebody has a debt, and then the debt collector is trying to collecting the debt, and during the process, they might have done some kind of practices in maybe threatening or pursuing or harassing in general. So then somebody like that would go to you, and then they would try to find out if there's potentially a case there.
Yes, and that's why because they're so broad, every case has to be looked at on its facts. And they come in 2 basic categories that have a lot of subcategories. The first one is abuse. What I described for you, calling 147 times a day after being told I don't have any money, I can't pay, we fall in that type of category. Another type, which has its own little subcategories, is really misrepresentation. And you'll find this as a classic example of 2 very common circumstances. One is falsely portraying who you are when you call. Common example of that back in the day, and still happens today, are people that pretend to be law enforcement officials, that I'm calling from so-and-so sheriff's department and I'm calling about your debt. You need to pay this money before we send someone out to arrest you. That is a violation of both acts, but based upon misrepresentation. Another more current one, which people are seeing more and more of now, is it's called spoofing. If you haven't seen Caller-ID spoofing, for your listeners, the Caller-ID spoofing concept is very, very prevalent now with the advent of VoIP telephone systems that are used by so many people to place phone calls, long distance calls particularly. When you have a VoIP phone system, which is operated on a computer, it allows you to use certain apps or programs to change what is reflected on the other person's caller ID, on the person who receives the call.
So it looks like your neighbors or something.
Well, that's one of the spoofing concepts that is used, is if you get a call from 1-800 somewhere or from an out of country phone call and you know you owe somebody some money, a lot of people will look at their phone and go, oh, I'm not answering that, decline. If it comes from your area code, you think it's someone calling locally, you're more inclined to answer it. Same thing, they may use this as part of the hacking that happens with the ID theft issues, is they will also use caller ID spoofing to pretend to be family members by getting access to their phone numbers. So they will use their phone number on the caller ID, and you think it's your mother calling you, and it's actually a bill collector. And those are violations that fall into the misrepresentation category, as an example, as opposed to the abuse category.
Wow. Okay, so somebody go to you, and then I mean, at what point should somebody go to find a lawyer like you, trying to see if there's a case?
The minute they have a belief that they've been abused or harassed by a bill collector, or if they've been misled or cheated by a bill collector, or lack of a better term, maybe pranked by somebody that might be a bill collector. And that goes into the caller ID spoofing angle. If you get a call from somebody and it doesn't seem like it's who that they should be, better chances to call a lawyer and find out what to do about that and how to handle that, because a lot of times that's the onset of a bunch of collection activity. Again, with the spoofing, if you catch it early, you can kind of catch the collectors when they're doing it. Otherwise, you may get 10, 20, 30 different phone calls from the same collector that are all using fake phone numbers. So they're not one time calling you 30 times, or one call number calling you 30 times. It's 30 separate phone calls from 30 separate phone numbers, but it's actually the same person. So it's hard to track that unless you catch it early.
So how would anyone prove something like that? Because, you know, the number changes every time, or whatever they say is on the phone, so you don't actually have a written record or a recording of it. So how would you prove something like that?
Well, that's a really good question. Couple of things are helpful there. The legislature, both federal and state, in Florida here, were very wise in some of their standards they imposed for the plaintiffs, the consumers, in proving these issues in court. The standard for a lot of these violations is what's referred to as the least sophisticated consumer standard. And this is a good example with the misrepresentation kind of stuff, where the debt collector will say something or do something that misleads a consumer. So when you go to prove those things, it's not whether the individual was misled necessarily, but whether the least sophisticated consumer would read that or hear what was said and become confused or misled by the statement. And that's really helpful because it lowers the bar for a lot of people. So if I get a guy that's a client, and let's say he's a doctor, and he's very sophisticated, well-educated, and probably isn't going to fall for a trick that someone pulls on him. This goes back to that attorney general kind of concept, where when we're enforcing that, it's not about that particular client being misled. It's about the conduct of the bill collector that can mislead other people. And when we catch them, we want to hold them responsible for when they did it to keep them from doing it in the future, whether that is by financial penalty or an injunction from the court. You mentioned class actions, or sometimes those types of cases where there's a generalized business practice or a pattern of conduct by a bill collector that runs across those things.
You mentioned injunction, meaning it will stop, the court will stop them from continuing to carry out that practice, or what does injunction mean?
Yes, in the classic sense of an injunction. Most of these types of statutes and remedies have the availability of injunctive relief. And a good example, since we were talking about it earlier, would be the caller ID spoofing concept. You could get an injunction from a judge that says you are stopped and can no longer use caller ID spoofing in your collection practices. And then it elevates not only from being a violation of the statute civilly, but then you have a direct court order which can give rise to contempt. So then you have contempt enforcement where they're disregarding a direct court order, and then that can escalate into the typical punishments you get for contempt, all the way up to what most people are aware of: a bailiff take Mr. So-and-so into custody, and we're going to put you in jail until you recognize you can't continue to do this to obey the court order kind of punishments that usually get someone's attention when they're doing something bad at that level.
I see. So how would you prove that they have done these things? Like what if you, right, go ahead.
And there's the second phase of that question that you had asked is a lot of that is where the lawyering comes into play and understanding some of the dynamics of what people are doing. Like the caller ID spoofing, unique to these types of issues is most people leave a digital footprint or a paper trail somewhere along the way about what they're doing. So if, as an example, say the call frequency, I gave you an example, 147 phone calls in 2 days. We can all generally agree that's ridiculous. And if the other side says, well, we didn't do that, then the first thing we would do is request or subpoena phone records from the phone company. Because if it's a long distance call, it's going to have reflected charges for those calls. If they have an auto dialer system, there's someone who programmed that stuff, and there's usually some sort of call tracking they use, even for their own internal auditing of whether collector A is doing his job by making so many phone calls a day versus collector B who's not, and who is he calling and how productive are they? So they leave a paper trail generally for those things that we can use.
So this is a record of the debt collector, not of the consumer phone record.
Well, sometimes there's both. One of the first things we tell our clients is if they're getting call frequency problems or harassment that way, is keep a phone log, keep a journal. I get a call from 1-800, whatever the number is, write it down, date and time, and who you believe that was, if you answered the phone, who they identified themselves are, and those things. And then we use that often with the other records we subpoena to correlate the two together, and that's when you get a lot of credibility. If my client says on June 1st at 1:00 p.m., he got a call from this number, that number is a number assigned to a debt collector, and if we get their records and it shows an outgoing phone call on their PBX system, a phone system as an example, with a long distance charge for 3.5 minutes of long distance call at that exact time, well, then they're connected together. That's a pretty good link. And a lot of these cases really involve at that level from a litigation perspective, showing the other side that we can show what they actually did so we can pull them out of the dark and into the light where it's going to expose what they're actually doing that they know they've done. We just have to convince them that we can show that we caught them. So that helps a lot.
I see. So what about the situation where you mentioned about misrepresentation, where they go on the phone and said, hey, I'm from the sheriff department. What if you go to court and then they say, well, we never train our people to say that. Our people don't say that. So how do you prove something like that?
That's a really good question. Couple ways we do that generally. One is one of the good advantages for these cases when they're tried, you're talking about in front of a jury, is most juries are comprised of people like most of the people that are subject to debt collection. People that are wealthy, people that have, high-end jobs, all try and get out of jury duty. The typical jury panel predominantly is going to be older people because they're retired and got nothing better to do, college students because they want to get out of school and go sit in court and be part of the system, and people that don't have a lot of money or resources because they're getting paid $15 a day, and if they're on disability or don't have a job, like the coronavirus stuff right now, if we were having the courts open, they'd all be sitting there, and they're the ones that are typically on the jury. The targets of most debt collectors usually make up the majority of people on a jury. That's helpful for consumers because one of the rare instances in American jurisprudence here is a trial of jurors that are like you. A jury of your peers, as the saying is. Doesn't usually exist in most instances here. It often does, and you're relying upon a jury to understand their own experiences when these people testify under oath that this is what happened to me, that there's probably some credibility there. Other ways that these things happen, and I've had many instances where this occurs, is whistleblowers. So in the course of litigation, when we're going through what's called the discovery process, we will often get a list of all the debt collectors that were assigned to or associated with a particular series of calls or collections on an account. One of the things we do, because we're a little more sophisticated than many lawyers, is we will also ask for a list of all the employees that worked there during that time frame that have left the company. Why? Because disgruntled employees that the company can't threaten with firing anymore, people that insiders that know what was really going on, are usually fairly eager to tell us about what those people were actually doing, because they don't have to worry about getting fired. They're not there anymore. And I've had many instances where that's happened, and suddenly you have like effectively a whistleblower that says, "Oh, I've sat in my chair and I've watched fights break out with debt collectors on the collections floor and people using profanity and threatening people." I've had cases where witnesses have testified about people threatening to use wrestling moves on debtors if they didn't pay the bill, and using fake voices and crazy stuff. It's mind numbing, the stuff that these people do.
Wow,
That
that's
insiders
crazy.
will tell you about, and that's helpful too.
Oh, wow. That is brilliant. So we talk about, making sure keeping a record of when they're calling, what kind of things they're asking, tracking to see if they pretending to be somebody else. And then when we go through trial, we're talking about subpoena, the phone record, getting potentially ex-employee, getting on the side of the jury. What else could help your case?
One of the things that's unique to debt collection cases, particularly, is while there are instances where you get a rogue collector, one person who's just a bad apple against all the cherries of all the other collectors, it doesn't usually happen that way. These are usually systematic type abuses, because that's how they're trained. They're not audited or monitored properly. So, and with the pressure that they have to collect and make money for the company, you get this natural tendency to keep pushing the envelope and the limits. So one of the things that happens, and we also do this as lawyers, is we start doing internet research and Google research and research within the court system to see, have they been sued other times? If this is the 437th time that company's been sued in the past month, it's a pretty fair bet there's a lot of other people out there that have experienced those same types of events that become witnesses in each other's cases sometimes. This also leads to the class action concepts that you had raised issue about before, where you start to realize these are systematic and pervasive violators. So a lot of times we'll get help from our friends, so to speak, where if one person was called an abusive, racist word on the phone, you look at it, you go, well, that might be hard to prove, and in today's day and age, maybe someone's playing that card to try and avoid a debt or something. So we as lawyers then look at things a little differently. Well, let's see if anybody else has complained about those types of words or threats or accusations being used in other collections events with this particular company. And if we Google them and we find on the Better Business Bureau or websites that have ratings or other sites that are there that have people reporting about debt collection violations, you might find that company ABC Collector has 300 complaints of using racially motivated threats and comments. And suddenly the person that was saying that gets a lot of credibility, because where there's smoke, there's fire. So that's one of the techniques that we use also to try and establish those things for clients that have those types of violations.
Wow, it's very broad. It looks like you're hunting like anywhere, and that's amazing. It's brilliant.
It's a very broad statute series, and it's intended to be that way because consumers have all kinds of interests that are very broad in themselves, whether it's a credit card, whether it's a car purchase with a repossession, whether it's a foreclosure or being behind on your mortgage. It could be an eviction event for owing the landlord some money. It could be a doctor bill where doctors' offices do things that they're not supposed to do, trying to collect money because commonly they're just too lazy to submit it to the right insurance company, and they'll turn on their own clients or patients and demand that they pay them monies they're not supposed to pay. One of the common examples of that is, I don't know if you've heard of balance billing. Most of the time when a doctor's office or a healthcare provider has health insurance or HMO, PPOs, Medicare, Medicaid, they have a contract that says they're going to get paid X dollars total for the bill. Well, Medicare and Medicaid as an example, those are often very low numbers. Some doctors' offices don't like to get paid those low numbers, so they turn around and submit the remaining bill to the customers, the patients, and say, well, the bill was $100, we only got paid 10, we need to make arrangements for you to pay 90. Well, that's illegal in many instances because it's called balance billing. That doctor's office is not entitled to that money, but the patients don't know any better. They don't want to anger their doctors because they don't want to interrupt their medical care. Well, we catch a lot of companies doing that, medical billing companies, things like that, where the doctors are happy getting the extra money and we have to sue them. And then we have what's called a disgorgement case, where not only we're suing for the penalties under the statute, but if they've collected money they're not entitled to for things like that, we will often, this goes back to like the injunctive issues, have a court order that they give up all the money they collected illegally back to the people they took it from. And that ties into that attorney general, private attorney general concept, where I may have one client that exposes that, but through that single case, force a debt collector that collected money from poor people or elderly people they weren't entitled to give all that money back to the people. And we know who they did it because we can use their own records to show, 500 people all paid an extra $100 they shouldn't have paid, and they need to be refunded that $100 from their own accounting records.
Wow. So I guess I have a bunch of questions there. Let's see if I can remember everything. But I mean, you mentioned about the private general attorney situation. Does that only apply for consumer rights situation, or does it apply to almost any kind of lawsuits?
It doesn't apply to every lawsuit, unfortunately. It is unique to the debt collection practice lawsuit type of cases. Because the legislature decided that they're going to enact that particular statutory scheme to protect consumers from the abuses that were happening, basically in the 60s and 70s predominantly, where some of the things debt collectors would do was just insane, and got to the point, it bubbled up to the point the federal government had to intervene with the Federal Fair Debt Collection Practices Act. Ironically, Florida was at the forefront of that because our statute here predates the federal statute, and it's kind of like the federal statute was in part patterned off of what we were doing here in Florida in large part. So that was unique to that arena where the legislature said, we're going to create this, and the courts have recognized our capacity there. In general, you don't have that relationship where you go outside your individual case for benefit to society. It's just that individual's, obligations and entitlements at that point uniquely.
I see. And then the other thing is, we touched a few times about the class action lawsuit. At what point, as in like how many people involved, how many consumers involved, is there a number that it then can become more of a class action and not?
It's a vague number generally. The concept for class actions, so you understand how they are different from a normal case, is if you have a particular course of conduct by a defendant, a bad guy doing something, and they've basically done the same exact thing to a bunch of people, and the damages and harm they caused to all of those people is almost all the same, then you might be able to get what's called a class action set up. And the focus of a class action is, rather than try 500 cases individually, that you try one case or two cases factually, and the results of that apply to everybody collectively. That's where you'll get what's called a class representative, and their fact pattern is generally what's pursued because it's representative of all the other people that are making similar claims. So that's how classes work. So when you're talking about how many is enough, it depends on the situation. There's a general rule in many states. In Florida, generally, it's about 40 people or more. So if you get 40 people or more and you can meet those other criteria, they call commonality and numerosity, there's legal terms for those things. If you meet all those criteria, then you can apply to the court for certification as a class. And if the court decides that it's appropriate to have a class action, they would certify the class, and then it turns into a class action, is how that works.
I see. And then so you would still try at least two cases first, and then you potentially convert that into a...
Yeah, you would have a trial based upon X number of plaintiff cases that are brought before a judge or a jury. A trial happens, and those cases are deemed to be representative of the other litigants in the class. So as an example, if you tried those cases, say 3 cases, just random number, and the jury awarded $1,000 in each of those 3 cases, and they're all basically the same factually, then what would happen is that would be representative of the other people, and they would all equally be entitled to $1,000 each, as opposed to trying 500 cases over $1,000 violation. You would try a couple, and then everybody else who was a claimant would be applicable to that.
I see. Yeah, that makes a lot of sense. Before we continue, I would like to take a moment to thank one of our sponsors. This episode is brought to you by Lawyer.com. Lawyer.com is an advanced lawyer matching service. Users can find what they need by either calling a referral expert or fill out a referral form or search a comprehensive directory of over 2 million lawyer listings. For a free consultation, please visit our website at youcanwinin.com/lawyers. One of the things that I've noticed from your discussion is that one of the big things is the consumer awareness, because like you mentioned, there's a situation where, let's say, a patient being abused by the doctor building practice, they don't even know that they're being abused. They might just feel, or even just people that have a credit card bill or credit card loan, they just felt guilty as it is, like, oh, I lost my job, I can't afford it, and now they're chasing me. So I think consumer awareness is a very big thing, isn't it? And how much education is out there for consumers to be aware of what their rights are?
Well, that's why you're here and why I'm here with you, because one of the things that's really important is getting consumers to be aware of these things. And there is an element of shame that people have that kind of prevents them from seeking help in those situations. And sadly, a lot of that is exploited by businesses and people like debt collectors or corporations that have a lot of debt structure to keep people believing that they should be ashamed or that it's their fault that they're being abused or treated badly. It's almost like gaslighting in a bad domestic violence relationship where they convince people that it's their own fault they're being abused.
Right.
And a lot of that does come from education, where you have to get people to understand there are remedies, there are limits to what people can do. And that is the challenge. One of my favorite examples of that, I do a lot of insurance litigation, suing insurance companies equally, is the insurance industry makes a huge effort to convince people that they shouldn't make insurance claims when they're involved in motor vehicle accidents because you're making the rates go up, or all these fraud people are out there. And they get to the point that they don't want to make claims that they've actually paid the premiums for, which I really don't understand as a lawyer, and spend a lot of time trying to get people to think correctly, because it's kind of like going to a fast food place and saying, I want a Big Mac or whatever sandwich you're getting for $10 and a fries and a drink, paying $10, then having the person come by and saying, hey, Tischhauser, you look a little portly there. We're going to give you a glass of water and a fruit cup. But I paid for the hamburger and the fries. Well, we've decided you don't need that for your own health. You don't want to be a fatty, do you? And at some point they get in your head, you're like, well, okay, so I'm paying $10 for a fruit cup and a glass of water, and they're making the profit. So that dynamic exists when you get a lot of these corporate entities dealing with debt structure and collections, where they get people believing that they should be ashamed to have a lawyer represent them to stop people from abusing them because, well, if they just paid their bills, it wouldn't happen. Well, but the law says it can't happen, regardless of whether you pay your bills. It's not a defense that somebody owes you money, that you send somebody down to break their legs, because it's real effective to get the money from them when you're breaking their legs, but the law doesn't allow that. And should be no shame for that, but there is a part of that is difficult to overcome. And a lot of what you're doing here today is really helpful for people, because they're going to see your podcast on these issues and realize, hey, there are people that can help me, and there are rights that I have. I just need to go and ask somebody.
I see. So what about, we're talking about the practice in how they're collecting the debt, but what about debt collector who, for example, pump in a very high interest rate?
I'm having trouble connecting to the internet.
I'm sorry,
Take a look at the help section in your Alexa app.
Alexa decided to join into our conversation. I'm sorry.
That's all right.
How about the situation where they go, well, because you're not paying debt, so now we're going to change your interest rate or something like that? Do you have that kind of situation, or where now you're going to owe so much more than you should have? Is there such situation?
Yeah, this is something that was really endemic to the credit card industry until they made some federal law changes that address some of these issues that really revolve around defaulted accounts where they ramp up your interest rates. Obviously, those are difficult to deal with because those are a little different, because at some point you're contracting in advance that I'm going to pay my bills as I agree to, and if I don't, there's going to be some penalties. So that's really hard to overcome. But there are instances where it becomes almost predatory. And I'll give you a great example of that in the consumer realm. We have a problem here in Florida. Other states have this also, with what are called title loan lenders for cars. And they actually structure their loans that they provide people to target elderly and poor people because they're vulnerable and they need money. So they have a car, if they own it outright, they can go get a loan. Like right now with the COVID environment, I got to pay my rent. I own my car, and I was on the internet, and this company says they'll loan me some money if I give them a lien or give them my car title. Well, the scam for a lot of those companies is they're not on the up and up. They're very shady. They specifically try to create circumstances to trigger the consumer into not paying the debt and defaulting so they can take their car. One of the weapons that happens with that is they add what are called financial products to the loans. And Florida has had some changes in our laws recently limiting some of that, but I'll give you an example of some of the more egregious circumstances. Let's say you wanted to borrow $5,000 against your car and get a $5,000 loan. You go to one of these particular title companies, and rather than just loaning you $5,000 against your car that's worth $20,000, they require that you buy what's called a debt cancellation product. That if you lose your job or somehow can't pay, that you're paying extra money that will allow them to just forgive your debt. But a lot of people aren't very sophisticated, or they're desperate, or they're elderly and not really knowing what they're doing. So they'll make these agreements where you'll borrow $5,000 from the company, but then to purchase this debt cancellation product, it costs you $7,500. So to borrow $5,000, they actually loan you $12,500 at a 20% interest rate.
Wow.
And the minute you hiccup on one payment, you got to pay every week on those things. They create as many opportunities for you to make a mistake as possible. They accelerate the entire loan. The entire thing's due, and you don't have to pay them the $5,000 back. You got to pay $12,500 back immediately. And if you don't have the money, which you don't normally have, that's why you're going to those people to start with, they repossess your car and take your $20,000 car they just literally bought for $5,000 and sell it and collect the money for this phantom $12,000 that's owed when it really isn't.
Wow, that is crazy.
Yeah.
So that is, I mean, I'm just,
I can see you can't wrap your head around that. You're like, that can't even be true. And I've had several.
That is crazy.
Yeah.
Right. So then they would go to you, and then what kind of cases would you, and what would you do in a situation like that?
Well, depending on where they're at in those transactions, traditionally my response is a little different than other lawyers. I want them to get their car back. One of the companies that we sued, and they're now out of business, and the Attorney General is stomping on them, was out of South Florida. And the problem with those people is if you try and get money from them, there's a series of news articles here in Florida about this company. I won't mention them. but the news media went down to their office, their home office in South Florida, and their entire office consisted of a desk, a chair, and a stuffed fish on the wall. That was the
Oh, that's a
entire,
lot.
yeah. I mean,
That's
that was the entire office for a company that had an internet presence that was selling millions of dollars of these loans and collecting up people's cars left and right. They got kicked out of another state and came here to do that. They're not operating now the way they were, but the hard part there is if I were to take those cases and sue them for the money back, good luck, because they don't have it. So a lot of times it's really important to get people, like I said, early, where if they just repoed the car, I can sue them and get a judge to order that they return the car back to the consumer. I can sometimes interrupt those efforts to sell the car so we can get that car back to the consumer and then deal with the money issues down the road. Sometimes if there are other companies doing that are more solvent, you'll do that and you're going to sue them for damages to make them pay legal fees and the recovery monies and the damages people have, because sometimes people lose their jobs from that. They're desperate. They need their car to go to work. I've had clients that need their cars to go to doctor treatments for cancer, and they will snatch them out of the driveway without a moment's care or notice. So a lot of times that's where we're going to shift from the traditional method of being a trial lawyer or suing people for damages to other things to try and help the client, like get their car back.
Yeah, that's very practical because you want to be protective of the client first.
Right.
So that's really helpful.
Right.
You brought
Sometimes
up
what's
another
really
thing.
helpful to them isn't what appears at first. It's something else that's more needed. So you got to be flexible.
Right. And then the other thing you mentioned is about the lawyer fee. How often is it that these clients would get the lawyer fees back? Because I mean, they were already in debt and in that kind of situation, and then that's the other things that preventing them going to a lawyer is because they
Right.
can't afford it. So how likely is it that if they win the case, they would get the lawyer fee back?
If the lawyers are being diligent in selecting the cases and which ones they can do those types of litigation on, very, very high. In fact, that's one of the good parts about the Florida statute and the federal statute for collections practices violation is not only is there a legal fee provision that allows the lawyers to recover fees for doing the work or the clients to get reimbursed if they had to pay for a lawyer, but in many instances, it's effectively a one-way attorney's fee. So again, the legislature wanted to encourage people to hire lawyers and stand up for themselves and fight against these debt collectors that are violating these acts. And part and parcel of that is creating an environment where the consumer doesn't have to be terrified of, well, what if I lose and then I got to pay all their legal fees at $400 or $500 an hour? I can't take that risk. And that's a real concern for people that are other than like the indigent type of person that's in that situation. If you're a homeowner or a middle-class person that's got like in the COVID-19 environment today as an example, you lost your job, but you have stuff and you expect to get your job back shortly and recover and be earning wages, you don't want to get involved in litigation to protect your rights on the chance you might lose for some reason. And then not only not get your rights enforced, but have to pay the other side because you happen to lose. And it could be something completely crazy, like because of COVID, your star witness got COVID and died. Well, that's not going to make you win at trial, and you're still stuck with those results. In the collections environment with the FDCPA and the Florida statute, the statute allows the consumer to recover fees, but does not allow the debt collector to recover fees. The exception to that is if the court decides, in Florida as an example, that the case was completely frivolous and brought solely for the purpose of harassing the bill collector, the kind of situation where you get smart and Google up some information on the internet, you figure, well, I don't want to pay this bill, so I'll say they said some terrible racist things to me on the phone and call me some profanities and things like that. And I know a lawyer will take that, and when he sues them, they'll run away and I'll get out of that debt. If you do that and get caught doing that, then you're going to get tagged for fees. But short of that, that doesn't happen. So that's really helpful for consumers because it puts them in a strong position not to be pressured financially out of fear to back off of the case. And that also feeds into that attorney general concept that we were talking about, where you want to push those issues to make sure those people are fully addressed with courts and the judges and juries that get to hear these issues, and they get to make those determinations and hold them responsible, that jury of our peers.
And so in those situations, do you do the consumer automatically get the feedback, or do they actually have to motion for it to get it back?
It's technically at the end of a case. Theoretically, if you win, you'd have to do a motion for the court to assess fees. It can go as far sometimes as actually being a miniature trial to determine what the reasonable fees are, and the court makes that decision and awards that for the consumer if they win. In reality, it becomes part of the settlement process. So when we file suit, I just had this happen yesterday on a case as an example. A debt collector will come and say, we want to settle this case. What's it going to take to resolve this? So we will usually give them a value that either is, X dollars plus legal fees, or a global value of, $10,000 as an example, including legal fees and costs and expenses. And in that case, we'll have talked to the client, said, here's what we have for fees. If we can get them to settle at this rate, we'll get our fees. Are you okay with getting this value for your damages? And then the clients can make that call. If they say, yes, we want to do it that way, then it kind of gets negotiated in during the settlement process. The vast majority of the cases, because of that one-way attorney's fee provision also, and the exposures that exist otherwise, debt collectors that know they've got caught with their hand in the cookie jar, so to speak, have a strong incentive to try and minimize their own defensive legal fees and the accrual of legal fees on our side by coming to the table early and trying to get the case resolved before it gets spiraling out of control. The worst nightmare for a debt collector is to know that they're wrong and be belligerent in defending the case, thinking that, well, I'm just going to steamroll somebody and spend a bunch of money and they'll never get me, because they forget that the more work they make someone in my position do to prove what we know is true, that they're wrong, at the end, you still got to pay the piper. And it could be $100,000 in legal fees in a small claims case that you rack up trying to not be caught. And when you get caught, you've got to pay that price at the end. And the Florida Supreme Court has been very staunch on that. Basically, if you pick the fight, you got to take the bloody nose. And if you lose, you're taking one for the team. Don't cry about it. So that incentive really brings those issues early on, where we're able to get the legal fees paid and get people compensation because of that structure. And that's really, really integral to those statutes. And that helps us get so much better benefits for the consumer, because the economic leverage has been evened out. If you're taking on $1 billion, bank that sells credit cards and services, credit cards and owns 5 other banks, they have more money at their disposal, and they can hire every lawyer in the state of Florida to defend the case against me. Right. Well, that would suck for every consumer if every time they just put their money behind it, and righteousness and the rulings of the court were determined on who spent the most money. So by balancing that playing field, by making the person that does that responsible for the end result, they have to weigh, do I want to pay Tischhauser $500,000 in legal fees on a case because I didn't pay someone $500 that I should have given back to them, or I balance billed $100 to a patient? The answer at some point has to be, you'd have to be stupid to spend $500,000 over $500. Right. And that's the encouragement to happen early on, to realize you've done something wrong and then negotiate that settlement and maybe do better in the future, but you got to accept what you did in the past.
So how long would a typical case might run? I mean, obviously it's different for every cases. And how soon have you seen the debt collector get to settlement? I've
had cases settle the day that they get served, sometimes.
I see.
If they know they've done something wrong, if it's obvious, I'll give you a really funny example. This is 20 years ago. I had a guy that I sued a company. It's a large company. I won't mention her name. President of the large company calls me and literally starts just cussing me up one side, down the other side. That he's known this bill collector at his company since he was a kid and he would never do such a thing. And he doesn't care what I say and what my client says. My client's lying. And I just let him go on. I'm just watching my watch, sitting going, okay. Get about 10 minutes, he's going on a rant. He got done. And I said, "Sir, I understand that. Let me play something for you." And what he didn't realize is that the debt collector that it was at issue made all the threats and statements on my client's voicemail message. So it wasn't my client saying, "Hey, this is what I said on the phone." He left it on a voicemail. So when I told the president of this big company, "Just hold on a second, let me play this for you." And all he heard was this, me rewinding the tape. And then I played the tape and he heard the words of the gentleman in his own voice saying all the things he said that guy would never say, ever. I remember hearing at that case a dead silence. And I sat and looked at my watch again. I want to see how long that was going to last before he spoke first.
Wow.
And it was about 2 or 3 minutes this time. And then the president of this large corporation tells me, "Mr. Tischhauser, I'm going to pay you everything you've requested in your lawsuit, every dime, every penny, on one condition." And I said, "What is that?" "I want a copy of that tape. I'm going to fire that guy. And I'm going to use that tape and his firing as a training mechanism for everybody else in this company."
Oh, so he's
So,
very, very good. He's a good guy. He has good intention.
well, some companies actually are not bad, evil companies. They just have people that go sideways or do the wrong things, or they go overboard in sometimes legitimate efforts to collect legitimate debt. There's also equally companies that literally are predatory. Used to be back in the day in Buffalo, New York. They're still around a bit, what I used to call whack-a-mole companies, that were companies that were opened up. They would buy, they're often involved with money laundering and things like that inadvertently. They would be assigned or buy portfolios of debt, and they would dial for dollars. And they would just literally hire people that didn't have jobs in Buffalo. It was incredibly depressed at the time. And they would be the most abusive, crazy, threatening people ever to pick up a phone and dial for collections. It was so bad that when a client would come in and describe what happened, I would say, "Was it this company or that company?" Or like, "How did you know?" Because I've got 37 lawsuits against that company. But what they would do is, well, I was like whack-a-mole, they would create a shell corporation and they would hire all these people and give them scripts to abuse all these people trying to collect money from them. Many of them are fraudulent debts. And when they gathered up a bunch enough lawsuits and judgments against them, or the FTC got involved, they'd shut the company down. It would just disappear. They would dissolve it. They would cancel the phone service. They would move from the company. They would vacate the property, and then lo and behold, a couple months later, instead of ABC collections, you'll see BCA collections. And the president's the vice president's now the general manager's now the president in the same company. And they're all the same accounts magically got transferred to that other company, because then you got to start all over again suing that company for the new stuff, because you can't go from one to the other very easily. So it's like whack-a-mole. You smack this one pops up. So you get that on the other extreme. But the point being is, when they settle early, sometimes you get stuff like that where they know they've done wrong. And even though they start off really aggressive, realize that they got to do what's right. And then sometimes you get people that you know are wrong, and they won't ever admit they're wrong. And you're stuck for 2 or 3 years of litigation, sometimes trying to get them to a trial, because you just have to go through that process. And I've had both extremes of cases in that realm. So,
wow. So yeah, you
never
really
know. You just got to sort them out and see.
Yeah. So what about lawyers as a consumer? What would you advise for the consumer to look for when they look for a lawyer? Like, what should they be looking out for, and what should they be asking?
That's a really good question. And I'll give you an answer that's not the conventional answer. What people need to do is their homework and think about the lawyers they're actually hiring. One of the things that drives me crazy in this arena particularly are pandering lawyers for cash. They're out there. They have lots of advertising dollars, and they're always smiling and tell everybody whatever you want to hear, just sign here. They become at some level like used car salesmen gathering up cases. And it really makes me furious because a lot of people will go to those lawyers and they'll have the case for 2 or 3 months and they think, oh my God, this guy's going to do something. And I know it's not a good case or there's a problem with it as a lawyer, but they think it's going to be a great case. They start relying on it, that they're going to get some compensation or whatever. Then they get that letter in the mail. Upon further review, we regret to inform you, and they drop the case. Well, that creates a lot of turmoil for those people because they don't know that's what they're dealing with as lawyers. There's lawyers that are just looking to mill cases through and they got to fight for somebody. You know, they don't want to do that. Now, the statute schemes really allow lawyers to be aggressive and push the envelope for the consumer in that way. Problem is, businessmen that are also lawyers, if they're not focused on the lawyering but on the business angle, a lot of times just looking for easy, quick cases. They can get some cash for legal fees for them, a little something for the client, move on. And that's the ones that I think are the most damaging for consumers. So I think consumers need to ask questions, you know, and one of the things that I always find amusing is I'm one of the more aggressive lawyers dealing with my own clients, to my own financial penalty sometimes, where people say, well, you're just mean. Like, well, I mean to the other side too, right? So, but the advantage for that sometimes is realizing that lawyers that are pushovers and are super agreeable with everything, they usually don't change their views of the world, and they're not critical and ask hard questions or aggressive. They have something that doesn't make sense. When the other side tells them a story, they go, oh, okay, that makes sense. I'll buy it. And then your case goes from here to over here because the lawyers aren't being aggressive. So a lot of times it's getting past the normal situation of hiring someone who's nice, who is pleasant, whether they're good looking, you know, whether they're old, they've been practicing a long time, or just fresh out of law school. There's benefits and problems for each end. If you've been practicing 50 years, you might just not be interested in aggressive litigation. If you're a young gun, just got out of law school, you might take all kind of cases and just, you know, literally hammer everybody as much as you can because you need the experience and you want to be aggressive. At the same time, if you're too aggressive, well, then you end up causing problems for the clients. If you're not aggressive enough on the other side, you get that balancing test. So the only thing I can tell people is ask a lot of questions of the lawyers. Have you tried cases like this? Have you done appeals? Is there anything of note, cases that you've handled that are that I might have heard about or seen? Google them, research them. Don't take everything at face value. You got to really look and see who you're hiring. Same thing with like Google reviews and Yelp reviews. A lot of people look for guys that have 5-star reviews. But anytime you see someone with all 5-star reviews, run. Because there's nobody in the world that can make everybody happy, 500 reviews deep, without, you know, by definition, if you're making everybody happy, you're not doing anything for anybody generally.
Right.
So you got to get past all that as a consumer. Like we were talking before about educating yourself. A lot of that really is education and experience and thinking about things yourself to make good decisions. And that all to me just starts with asking a lot of questions and seeing what kind of answers you get. If you get whatever you want to be told answers, that tells you what you're dealing with. If you get someone that gives you honest answers, even if you don't like them, that may tell you who you're dealing with also. And my personal view is I want someone who's going to tell me the truth and shoot me straight and keep me in a good position. Because if you can't trust your lawyer, you can't trust anybody, because that's the person you have to trust the most in those situations.
Right. That's the only person that you can supposedly count on. Right.
Yeah. And if you have any question in your mind or your heart about, you know, I don't think that lawyer has my interests, or he's not doing for me, or he's more interested in getting some money for himself, and I'm just a pawn in the middle, you really got to be aware of that as a consumer and make some other decisions early and effectively, so you don't get caught in that situation. Because lawyers, like everybody else, there's a lot of really great lawyers out there, but I'll be the first to tell you it's not everybody. Just like debt collectors, not all of them are bad apples. There's a bunch of bad ones, but there are people that will step to the plate and do the right thing if they're caught and shown that they've done something wrong. So hiring a lawyer goes on that same path.
So from the conversation that we have, it seemed like it's a very complicated area of the law. So it seems like it's impossible for consumer to just represent themselves without a lawyer. Is that true?
Well, ironically, in that arena, it's actually a detriment. That's a really good question, because a lot of pro se litigants like to try and use the FDCPA or the state counterpart. I'll give you an example of where they do that and it doesn't do anything for them. In 99% of those cases, the biggest threat to the consumer is not the damages they did to the consumer. Now, to the consumer, that's the most important part because they've been damaged, not to the debt collector. So I'll give you a good example. I've had cases where gone to trial and a jury might award $2,000 in damages. Now, the debt collector wouldn't give that money up, and they're the ones that forced us to go to trial to get it from them. But that debt collector might pay $150,000, $200,000 in legal fees to me to beat that out of them for what they should have paid up front, which is $2,000. Now, if you don't have a lawyer handling that case on a $2,000 damage case with a $200,000 threat hanging over the debt collector's head, how do you think they're ever going to pay? They have no reason to pay a dime other than make the consumer representing themselves go to court, because the most you're going to pay is $2,000, whatever the actual damages are. A consumer, a pro se litigant, cannot get legal fees awarded to themselves unless they're an attorney. And that actually takes away one of the biggest weapons that a consumer has to make the other side play fair, is the threat of the legal fees they have to spend on the lawyer on the other side when they lose. So by taking that off the table, you're limiting your effectiveness. A good example of that also, talking about the landlord-tenant environment, it happens with security deposits. In Florida, when you pay a security deposit for your residential tenancy, the landlord keeps your money in a escrow account. When you leave, they have to send you a notice that says what they're assessing against your money, the security deposit, right? Well, if you can't come to an agreement on it, somebody has to sue somebody in court over that value. There is an attorney's fee provision for the Landlord-Tenant Act that whoever wins gets their legal fees reimbursed. But if you're a pro se litigant and you demand that you get your money back from the landlord, he says, I'm not giving it to you. When you go to court, if the landlord loses, he's giving you your own money back. He's not even losing anything, right? So you win and get your own money back from the landlord and the cost of filing the lawsuit. So what incentive would a landlord have to ever give you your money back legitimately other than fight with you? If you hire a lawyer to handle that, which is sometimes these are tactical things that are necessary. Now, if the landlord doesn't want to give you back your $1,000 security deposit and the lawyer spends $10,000 beating that landlord out of it, now the landlord gets to pay $11,000, $1,000 security deposit and the $10,000 legal fees back to you.
Yep.
And they may lose their house that they have as an investment rental property or something in the mix. And that dynamic changes 180 degrees because now the landlord's afraid if he creates protracted litigation, the 10 becomes 20, becomes 30, becomes 50, and he could lose his investment in a property. I had a landlord almost do that one day over one of these cases. The irony is he wanted to hire me afterwards. But literally he got himself in a bind. He went through 5 lawyers defending the lawsuit and finally had to come to the conclusion he was wrong. But he had to pay a bunch of money because it was a landlord-tenant case over a security deposit involving a collections violation. And that guy finally had to come to the realization all that strategy of stonewalling and obstruction and didn't work. And all he did was make a bigger fee for him to pay in the end because he still could not escape that he was wrong.
So yeah, so it's definitely more beneficial for the consumer to get representation.
Yeah.
That is
in this area particularly, there are many areas where there aren't fee provisions or attorney's fee statutes that come into play, where it is helpful for people that they can represent themselves effectively. This is not one of them, even when they're small claims type cases, because the major leverage mechanism is the exposure of the other side to your legal fees if you win. That's what that evens the playing field in that litigation case.
That is such an important insight that consumers don't normally have.
Right.
You know, that's so important. Thank you so much. I mean, like we talk about so many things and I found it like I learned a lot actually. So thank you. I mean, other than work, tell us a little bit about yourself.
I'm a typical trial lawyer. All I do is work. I literally live in my office, I think sometimes, but that's
Oh my
important
God.
because, you know, it's one of those things. It's when you're, it's a passion for you. You really, as a consumer lawyer, if you're not doing it because you're passionate about it, it'll drive you crazy. So, you know, personally, you know, literally that drives everything I do, is trying to help people through, you know, my practice and help people as consumers, and you know, whatever I can do to do that, that's what we do.
Wow, so your clients are very lucky actually. So that's great.
Well, I'll
Thank
tell them
you.
you said so, so they'll all know.
Thank you so much. And I'm gonna put in the show notes like the link to your website so they can reach out to you. And
Absolutely.
really, yeah, appreciate it. You shared so much.
No problem. Hey, if you need any other questions in the future, just give us a call. We'll be happy to help you if we can.
Thank you so much for tuning in. If you have any questions or suggestions, please let us know. And if you find value from our program, please subscribe, share, and leave a review. You can also support us by becoming a patron. The link to our Patreon page is on our website at youcanwinin.com. Stay wonderful.
Please note that the discussions here are not intended to substitute for legal advice. Please seek the advice and help from a lawyer regarding any legal matters.